Good afternoon, everyone. It looks like it's straight up 12 o'clock, so we'll go ahead and get started. Today, we are going to be talking about the hospital price transparency final rule that was just published by CMS on November 15th. My name is Lisa Carlson, and I am an attorney with Holland & Hart, and I am based out of the Boise office, and I practice primarily in the healthcare group. So obviously this presentation is for educational purposes, but I do want to encourage you to ask questions if you have any, and you can do that by using the Q&A icon that should be on one of the menu bars within your web application. If you do have a question, feel free to ask that. I likely will not get to have time to answer those questions, but certainly we'll follow up with each of you individually after this presentation in order to make sure that your questions are satisfied. So first of all, the overview of what we're going to talk about today. Going to start out with the history of the rule, sort of how we've arrived at where we're at today, and then of course the statutory authority that CMS is relying on for issuing these regulations. Then we'll go into the applicability of the rule, so who really needs to be worried about the content of this rule. Third, we'll talk about the public disclosure requirements. This is really the meat of the rule. This is what do you need to do in order to comply. Then we'll talk about what I like to call the teeth of the rule, the monitoring and enforcement authority that has been conferred on CMS to make sure that folks are complying with the rule. And then finally, I will wrap up with some brief comments about the pending litigation. So I'm sure many of you have heard that this rule is hotly contested, and before it was even issued, folks in various industry associations were promising litigation, and they have in fact delivered on those promises. So we'll talk about that briefly as well. So as far as the history of this rule and the authority, so Section 2718E of the Public Health Services Act was amended in 2010 by the Affordable Care Act. This amendment required hospitals operating within the United States, so pretty broad application there, to establish, update, and make public a list of the hospital's standard charges for items and services provided. Obviously, the next step would be for the agencies to then promulgate those rules to say what exactly does that statute mean that's passed by Congress. So in 2014, CMS issued a final rule, not really requiring compliance, but encouraging hospitals to comply with the transparency requirements of that section. And then fast forward 4 more years, CMS then issues a final rule requiring hospitals to publish a list of standard services in a machine-readable format on their websites. This rule became effective in January of this year, but there's still a little bit of gap as far as folks in CMS thinking this isn't really enough to ensure the transparency that we think is necessary under that Section 2718. The current administration would agree, and in June of this year, President Trump issued an executive order essentially directing federal agencies to, among other things, propose additional regulations to ensure that patients are meaningfully informed and able to compare prices across hospital systems to make their healthcare decisions. So now, present state, November 15th, the CMS issued their final rule for hospital pricing transparency that we're going to be talking about today. So as far as this rule, we've got a little bit of a time frame here where we can come into compliance. So CMS actually delayed implementation for a full year, so until January 1st of 2021, so that hospitals would have sufficient time to collect and display the information that the rule requires. Now we'll move on to applicability. So again, Section 2718 applied to all hospitals in the United States. So what ended up happening is CMS said there aren't really any good definitions of hospital within any of the current statutes or any of the current regulations that would really encompass the broad scope that Congress intended with this particular requirement. So they decided that they needed to come up with a new definition of hospital, and so they did. So for purposes of this rule, a hospital is an institution in any state in which state or applicable local law provides for the licensing of hospitals, and that is either licensed as a hospital pursuant to that law or approved by the agency of that state that's responsible for overseeing hospitals and establishing those standards for hospitals. So what you'll note is that Medicare enrollment or designation is not relevant to whether or not an entity is a hospital. It really depends on what the state, what you're designated in the state in which you're operating. And as far as what state, the definition of state, they've even decided that state is going to include not just the 50 states, but it will also include District of Columbia, Puerto Rico, Virgin Islands, Guam, American Samoa, and the Northern Mariana Islands. So it's very broad. Any hospital that's designated as such within their geographic location that's part of the United States is going to be subject to the provisions of this rule. Now, it does not include ambulatory surgical centers or other non-hospital sites of care. In the regulations, CMS specifically said that, even though it doesn't apply to you, if you're one of those entities, you certainly are encouraged to comply because obviously they're on a trajectory toward ensuring transparency to patients, and the more transparency, the better. But even though those particular facility types are outside the scope of hospital under the authority in the statute, CMS is still encouraging compliance. It includes all hospital types. So critical access hospitals, psychiatric facilities, community hospitals, inpatient rehab facilities. Again, if you're designated a hospital, the rule will apply to you, including any off-campus or outpatient departments. Significantly, some hospitals may have multiple locations operating under one license. CMS specifically has stated that if you have different charges for these different locations, each location will have a separate obligation to list charges. So just because you only have one license but multiple charges at different locations, you will have to comply at each separate location and list the charges specific to that location. And of course, there's always an exception. So they've deemed that federally owned hospitals like Department of Defense or VA hospitals are already in compliance, as well as any hospitals operated by Indian health programs. So that is the definition of hospital and who this rule will apply to. So going into what is required under this new rule. And as you can see at the bottom, I've noted where these rules will be recorded once they become effective, and they will be found in 45 CFR 180, Part 180. So the two basic public disclosure requirements are as follows, and you'll see I've underlined some terms in here, and these are defined terms that are defined in the regulation. So I will go into what each of these means later. So the first is that the hospital must make public the following. First, a machine-readable file containing a list of all standard charges for all items and services. And then second, a consumer-friendly list of standard charges for a limited set of shoppable services. So I will break down each one of those. So as far as the first one, a machine-readable file. Machine-readable means a digital representation of data or information in a file that can be imported or read into a computer system for further processing. And so they've given the specific examples of file formats that they will deem to be permissible. Those would be the .xml, .json, and .csv formats. They've specifically stated that a PDF would not fit the definition of machine readable because it does require further formatting, processing, and it's not easily readable across a wide variety of systems. So a machine readable list of standard charges. So standard charges is defined as the rate established by the hospital for an item or service provided to a specific group of paying patients. And it includes the 5 types of standard charges that I've listed below. So each one of those 5 types of standard charges is also a defined term. But it's important to note that any time CMS says in the rule standard charges, they mean all 5. So you don't get to just list one or the other or cherry pick which one you want to provide in your list. You do have to provide all 5 reference points. So a gross charge is defined as a charge for an item or service that's reflected on a hospital's charge master absent any discounts. So basically, that's just going to be your standard charge, your basic list with that hospitals have relied on and what was included in the requirements of the January 1st, 2019 rule was list your charges in your charge master. So that's what that is. Second, though, you now have to include payer-specific negotiated charges. That would be the charge a hospital has negotiated with a third-party payer for an item or service. Important to note with that is that it also has to include the specific payer, the name of the specific payer, and the plan that that's associated with. As far as number 3, the identified minimum negotiated charge, and number 4, the de-identified maximum negotiated charge, it's basically you're going to be looking at a range. What's the lowest charge that the hospital's negotiated with that third-party payer, and what's the highest charge that they've negotiated with all of their third-party payers? And then on number 5, the discounted cash price, that is the charge that applies to an individual who pays cash or a cash equivalent. And so that would not consider charity care or sliding scale prices. And notably, third-party payer is also a defined term, but it's generally an entity that's either by statute or contract or agreement that's legally responsible for paying a health care claim. Also, you'll notice that there's no requirement to post any Medicare or Medicaid rates, and that's because they've deemed those to be non-negotiated. So if you don't negotiate the charge, it's not required to be posted. Finally, you have to post machine-readable standard charges for items and services. And items and services is another defined term. So an item and service is defined as all items and services, including individual items and services and service packages that could be provided by a hospital to a patient in connection with an inpatient admission or an outpatient department visit for which the hospital has established a standard charge. And they've provided examples. So examples are supplies, procedures, room and board, facility fees, professional charges, and any other item or service with an established standard charge. Significant to these examples is the professional charges. Yes, you have to include professional charges. However, you only have to include professional charges for employed physician or employed non-physician practitioners. So if they're not employed by the hospital, then you do not have to include those in as a standard charge item and service. Also, CMS has provided hospitals with some flexibility as far as what does it mean to be employed. They say they're not going to prescribe what that means, but instead are going to look to hospitals to rely on their organizational structures and policies and act in conformance with those documents in determining who's employed for purposes of disclosing the prices of these items and services. So Of course, there's always the service package definition, which is essentially it's an aggregation of all of your items and services and then assigning one charge to that aggregate. So again, within the definition of items and services, it contemplates that if you do bill in a manner that contemplates service packages, that you will provide the price for that service package as well. So going into some more of the nuanced details of this requirement beyond the definitions, the list must include a description of each item or service that's provided by the hospital. And also, as I mentioned earlier, needs to include all 5 standard charges in both inpatient and outpatient settings. So if it's provided in both, you need to list the prices for both. And as far as for payer-specific negotiated charges, again, you must include the name of the third-party payer and the plan that that charge is associated with. And then finally, the list must include the code that's used by the hospital for accounting or billing. So CPT codes, HCPCS codes, DRG, NDC, whatever the hospital is using and relying on must be provided in that list. The list must also be updated annually. You also have to include the date that the list was last updated, so you can either include it as part of the list or affiliated with the file type somehow. You can, whether it's when you click on the link, it can say last updated on such and such date, but it needs to indicate how recent that, how up to date that list is. It needs to be published in a single digital file that is digitally searchable. Now, in the comment process, a lot of folks came back and said that that's going to be a huge file. It's going to be impossible to host. It's going to be expensive. It's going to take a long time to load. It's going to take a long time to search. And CMS's response to that was to point to the Medicare provider utilization and payment data files that they host on their websites for common inpatient and outpatient services. And they said, if we can do it, and I'm paraphrasing significantly, but basically if we can do it, you can do it. So single digital file, digitally searchable, listing all charges. The list must also be easily accessible on a publicly available website, displayed prominently, and without barriers. So I've italicized these because while they're not defined in the regulation, the rule did set forth the definition or their interpretation of what these terms mean. So easily accessible means that that it's going to be presented in a machine-readable file that's searchable and on a website that can be accessed with the fewest number of clicks. So you can't really hide it, on maybe a page with a bunch of subpages and make it really hard for people to find that information. It needs to be easily accessible. Secondly, displayed prominently, sort of building on the easily accessible notion. It means that the link to the standard file is going to be visually distinguished on the web page. And they use the term no reliance on breadcrumbs to help with navigation. Essentially, that means don't bury it, like make it displayed on the website, make it readable, that you don't have to click a bunch of different links to get to the file where the data is housed. And then finally, without barriers means that the information can be accessed free of charge, that users don't have to input their information like their name or their email or any other personal identifying information, and don't require folks to log in or just to use the standard data file. And then finally, they've even gone so far as to require a specific naming structure for this file, which I'm not going to try to read, but it's at the bottom of the slide. And so this is what the expectation is as far as that data file, how it's going to be easily located, easily identified based on the naming provision. And so I on the next slide, they did provide a table as a sample, and again, hospitals are going to have flexibility. Do not have to mirror your data file identically to the one that they've provided, but really they wanted a sample for folks to look at to say, this is what we anticipate, or this is what we have in mind, we're envisioning when we say a table of the standard charges. And as you'll see, this particular table is a sample of gross charges. And as I mentioned, you have to have all five charges. So this would only satisfy one of the standard charges. So you would have to also include the cash and the third-party charges within this table. So again, just a sample document so that you can see you've got your different coding, you've got your outpatient, your inpatient, and then quantity considerations that may go into factoring how much something costs. And that's it for the first part of the rule. So the second part of the rule, again, is a consumer-friendly list of standard charges for a limited set of shoppable services. So what does it mean to make something like that public? Again, with the definition. So shoppable service is a defined term. A shoppable service is a service that can be scheduled by a healthcare consumer in advance. CMS in their comments even mentioned that they have estimated that up to 40% of all healthcare is something that can be scheduled in advance. So that's part of the rationale for why they feel that shoppable services is a great data point to use and something that consumers should have readily accessible in making care decisions. It's also important to note the definition of ancillary services. So even though it's not called out specifically in that last slide in the requirement of public disclosure, an ancillary service is an item or service that a hospital customarily provides as part of or in conjunction with a shoppable primary service. And the expectation is that if there is an ancillary service that typically corresponds with the shoppable service, the hospitals will disclose the price of both. So if you can't get a shoppable service without an ancillary service, then you really need to be disclosing both of them to the patient for their transparency and healthcare decision-making needs. So the rule is that you must make public a consumer-friendly list of standard charges for shoppable services. CMS has decided that the limited set of shoppable services, say that 3 times fast, consists of 300 shoppable services. So where do they come up with 300, that number? So what they've done is they've come up with 70 specified shoppable services, and they do provide a list, which is on a subsequent slide that I will scroll through here in a minute. But there's 70 CMS specified shoppable services, and they expect those to show up on the list. If a hospital or facility does not provide one of those 70 CMS specified services, then the hospital has to indicate that it's not provided. I can't just omit one of those 70 off the list, leave it there, and make a notation, not provided. Hospitals are also expected to include an additional 230 shoppable services that they can select. So the requirement is that you have a total of 300 shoppable services. So again, if you only had 65 of the 70 CMS services, you would then need to provide 235 hospital-selected shoppable services. Additionally, if the hospital or your facility does not provide 300 total shoppable services, then that's, of course, permissible. You don't have to provide prices for services you don't provide, obviously. And as far as guidance on how hospitals are expected to select their shoppable services, there's not as much discretion as maybe you might like to think, that you get to just pick the 230 that you like best. Instead, it's expected that hospitals will select the 230 based upon utilization or billing rate of services from the prior year. So you're basically, it's intended to capture the most used services at your facility. The list must also include a plain language description of the shoppable service. Again, as I mentioned, an indicator when one of those CMS specified services is not offered. It must include all 5 standard charges for both inpatient and outpatient settings, and corresponding ancillary services and the charges for those. For payer-specific negotiated charges, again, it must include the name of the third-party payer and plan. It has to include the code that the hospital uses when billing, and then also the location where the shoppable service is provided. So if it's inpatient, outpatient, or both. As far as additional requirements of the list, well, actually first, here's the list of the 70 CMS-specified shoppable services. You can see they've listed the billing codes and then just a description of the services. So I think it's like 3 pages long. So my slides are actually available after the presentation. I should have come out with a reminder, a link to the slides, so you're welcome. Or you can just go to the final rule. These tables are included in the final rule as well. So these are the 70 shoppable services that CMS expects to be included. Okay, so additional requirements that go along with the list. Again, similar to the machine readable list, it must be updated at least annually and clearly indicate the date that it was last updated. It must be displayed, again with the buzzwords, in a prominent manner on a publicly available website and easily accessible with no barriers. And then there's a little bit higher searchability requirement, so you must be able to search by service description, by billing code, and by payer. So interestingly, in the comments, some hospitals, and largely in part, various states have imposed requirements to try to improve the transparency and the sharing of cost information with residents in their state. So some states have imposed regulations on hospitals to share costs. And so some hospitals are already maybe a little more advanced as far as sharing cost of services with the public than other hospitals. And so in the comments, CMS contemplated some of these hospitals that already have price estimator tools in place and said that, so part of this rule is CMS acknowledging that they will deem an internet-based price estimator tool to comply with the requirements of this portion of the rule, the consumer-friendly portion of the rule, that this price estimator tool will comply as long as it provides estimates for the 300 shoppable services, allows consumers to obtain an estimate of the amount that they'll be obligated to pay for the shoppable services, and then again is prominently displayed not just on a public website but on the hospital's website and easily accessible and without barriers. Essentially, they indicated that they believe that the price estimator tools are actually going one step further than what the rule requires because it's taking the information that's required by the rule to be disclosed and that the consumer would otherwise have to use in order to determine ultimately the end goal is what is my obligation, what's going to be my financial obligation from obtaining this health care. And so to the extent that this internet-based price estimator tool does that for the consumer, CMS was supportive of allowing these tools to satisfy the requirements of this section. Notably, CMS also included some recommendations as far as language that they think should be included as part of these disclosures. They encourage hospitals to include disclaimer language that the consumer will need to confirm out-of-pocket or their own contribution amount with their independent third-party payer. They also encourage notification to the consumer of the availability of financial aid or payment assistance plans or assistance with enrolling in Medicaid or Medicare, and also an indicator of quality of care. If that's something that the hospital has available, they encourage disclosure of that. And of course, the requirement that any disclosures that are being made to the public are made available in other language, specifically that estimates would be available in other languages. The next page is a sample. Again, CMS provided a table sample of shoppable services, so what they have in mind. This is for a particular healthcare plan, so a third-party payer. That would be one of the standard charges for a third-party payer. Again, hospitals have ultimate flexibility in how they're going to convey this information in a consumer-friendly manner, but this is just something to use as a reference point, a starting point. So going into, like I said, the teeth of the rule, monitoring and enforcement. So the regulations give CMS significant authority for monitoring compliance and then imposing penalties through enforcement. So as far as monitoring, CMS has indicated that they will primarily monitor hospital compliance with the rules through public complaints, through a hospital's own self-analysis of their compliance, and then through CMS's own efforts of going to hospital websites and conducting audits to ensure that they're displaying the information that they are supposed to be displaying and in the way that they're supposed to be displaying it. As far as the enforcement, if they find a violation, if a hospital fails to make its standard charges known or fails to adhere to the manner in which it's supposed to display that information, that's deemed a material violation. So hospitals will receive a written warning, potentially can be required to submit a corrective action plan for those material violations, and CMS can impose a civil monetary penalty and publicize the hospital's noncompliance. As far as the civil monetary penalties that are available, if a hospital fails after submitting a corrective action plan, either they fail to submit it or fail to comply with it, then they can be fined from the moment of noncompliance. They can be fined up to $300 per day until they become compliant. And as far as appeal, this regulation has significant provisions regarding hearings, right to an appeal, and the process for contesting CMS's determination of material violation. So a hospital can appeal the imposition of a civil monetary penalty. And one thing to be mindful of is if CMS does send you a written warning and impose a civil monetary penalty, that you have to request that hearing within 30 days in order to contest that imposition of the fine. So just something to be mindful of. Not going to go too much into the process for requesting hearing and appeal because we're all going to assume that everybody's going to be 100% compliant come January 1st of not 2020, but 2021. So 12 and a half months. So to wrap it up, I'm going to talk briefly about the pending litigation and some of the concerns with this particular rule. So as I mentioned earlier, when the rule was first proposed, some hospital organizations and professional associations came forward and said, we think that this rule exceeds the statutory authority of CMS, and we will fight this in court. And true to form, as soon as the rule was published on November 15th, these associations banded together. There's, I think, 4 professional associations that I've listed up here, 4 or 5, and then 3 hospitals as well. And they've all joined together and filed a suit that was filed on December 4th, so not long after the rule was published. And they filed that in the court in the District of Columbia. And they've already filed a motion for summary judgment, I believe. And essentially, their claim is that, number one, that this rule exceeds CMS's statutory authority, that they don't have authority to be mandating these disclosures from hospitals or private payers, that it violates their First Amendment rights through disclosure of confidential contractual rates, and finally, that it's arbitrary and capricious. Essentially, what their argument is that what consumers really want to know is out-of-pocket expenses, which requires disclosure by insurers, not hospitals, and that ultimately this rule frustrates consumers. It will really confuse them more than it will help them by providing them with so much data overload of information that they can't actually use in a meaningful way to understand what their actual financial obligation is going to be, because so much of that is going to depend on what their contract with their insurance or third-party payer is going to require of them. And curiously, there's also, at the same time that CMS published the final rule that we're talking about now, they also published a proposed rule that will apply to group health plans and health insurance issuers if it's finalized, and they will essentially be required to disclose on a public website the same types of things that this rule requires hospitals to disclose. So I think what's important to note about the pending litigation is that they've asked for an expedited decision. They've acknowledged that hospitals have to comply within the next 12 plus months, and so hospitals are going to start expending some resources to come into compliance and to consolidate this information and make it accessible to consumers through their websites. And so if it is going to be struck down as impermissible, then we need to get to that decision as quickly as possible. Important to note is CMS anticipated that this rule would be contested. They have specifically issued some statements saying that they believe that they're on firm legal ground. And as far as those 5 standard charges that as part of the definition, that 3 of them are specific to contractual rates, which is part of the argument that violates the First Amendment rights of the hospitals and having to disclose these privately negotiated rates. CMS did make each one of those standard charges enforceable severably. So what that basically means, if I can speak, it means that even if the court says, well, that having to disclose that particular standard charge is unconstitutional and would violate their First Amendment right, there's still an opportunity for the court to say, but the hospital should still disclose their price discount and their gross standard charge. So it's very much up in the air as far as, again, whether CMS even had such statutory authority to promulgate this rule in the first place, and then if there's any constitutional violations with the content of the rule. There's additionally a parallel rule that applies to pharmaceutical companies and disclosure that's being challenged in court right now. So I think it's just important to stay abreast of what's happening with this particular litigation. If you're a hospital and you're wanting to know how much money do you throw at becoming compliant, as is, the rule stands, but certainly stay tuned as far as the case law developments and where this ends up in the next several months. And then finally, I have provided some resources that if you want access to the slides, I've included some links for the actual final rule. It's not yet published in the Federal Register, so I can't give you a site to that, but you can certainly link directly to the final rule if you feel like reading through 300 pages of comments and responses. Additionally, there's the CMS FAQ and press release related to this rule. And then, as I mentioned, they did issue a proposed rule on that same day that applies to health plans and health insurance issuers, and I've included the link to that rule as well. So again, that concludes the presentation. If anybody has any questions, please feel free to reach out to me directly. You can type in a Q&A on your screen, but I'd be more than happy to speak with you and answer any questions that you have. And this webinar has been recorded and will also be published on the Holland & Hart website. So again, thanks so much for attending, and I hope you have a great afternoon.